The Court of Appeal has dismissed an appeal brought by 4 organizations which sought a declaration that the existence and establishment of vernacular schools and the use of Chinese and Tamil languages in those schools are unconstitutional. A 3-person Court of Appeal bench unanimously dismissed the appeal by the Islamic Education Development Council, the Confederation of Malaysian Writers Association, Ikatan Muslimin Malaysia, and Ikatan Guru-Guru Muslim Malaysia, which challenged the school's legality. In reading out the ruling on behalf of the bench, Judge Azizul Azmin Adnan pointed out that the framers of the Federal Constitution had intended from the very beginning that pre-Merdeka vernacular schools would continue to operate with constitutional validity after independence in 1957. Azizul said this is reflected in Article 152(1)(b) of the Federal Constitution, which empowered the federal government to sustain and safeguard the utilization of Mandarin and Tamil as mediums of instruction in vernacular schools. Azizul added that it cannot be argued that the framers of the Constitution intended that schools that use language other than Malay are unlawful. He said otherwise, such schools would have been abolished with the establishment of the Federal Constitution. When met by the media at the lobby of the Palace of Justice in Putrajaya after the open court proceedings, the NGO's lawyer, Muhammad Hanif Khatri Abdullah, said an appeal will be filed at the federal court. The 4 NGOs were appealing against 2 separate civil court rulings that dismissed their legal challenges over the constitutionality of vernacular schools.